Good evening. My name is Gary Cazalet. I'm a member of the Faculty of Law at the University of Melbourne, and my role tonight is to introduce Anna Funder and Philippe Sands and allow Anna and Philippe to have a conversation on stage. This afternoon or early evening we have two brilliant writers and investigators talking with us. When I first read Anna Funder's book Stasi-Land, soon after it was published in 2002, I thought what an extraordinary story she had written. Stories of people who resisted the dictatorship in East Germany and the Stasi, the Secret Service. The book was a compelling read, but it was more than that. It reminded me, and I think all readers, of the brutality of man and how close that was to the surface, and what happens when one system of thought takes over. I thought at least it's in the past. It's part of the historical record, the close past, but in the past. And it's something we could read and learn from. Anna wrote about an interrogation in her book as follows. The interrogation of Miriam Weber took place every night for 10 nights for the 6 hours between 10 p.m. and 4 a.m. Lights were out in the cell at 8 p.m. and she slept for 2 hours before being taken to the interrogation room. She was returned to her cell 2 hours before the lights went on again at 6 a.m. She was not permitted to sleep during the day. A guard watched through the peephole and banged on the door if she nodded off. Anna goes on to say, sleep deprivation can mimic the symptoms of starvation, particularly in children. Victims become disorientated and cold. They lose their sense of time, becoming locked into an interminable present. What you'll hear tonight when Anna talks with Philippe Sands, is that this brutality that took place in East Germany has also been taking place in Guantanamo Bay and in Iraq at the instigation of one of our allies. Philippe Sands, QC, is a practising barrister and Professor of Law at the University College London. His book, Torture Team, examines the US administration's sanctioned abuses in Guantanamo Bay and Iraq. And I think as you read through the book, if you haven't read through it, or if you do read through it, you will see that what happens in Guantanamo Bay and Iraq is not so different as to what has happened behind the Iron Curtain. Please welcome Anna Funder and Philippe Sands.
I'm just saying how happy I am to be here tonight in Melbourne and also to be here with Philippe about his book. I'm slightly quaking at the kind of barristerial majesty of Philippe's oratorial skills. He's just offered to take 3 questions in a row and then add them up to 9 questions in a row when we finish, which is going to be quite something to see. I've got my questions here, being mortal. I wanted to start by engaging in a perhaps very unsavoury thought experiment and go back and imagine the minds, ourselves in the minds of President Bush, Vice President Cheney and Defence Secretary Donald Rumsfeld at the end of 2002, because Philippe's wonderful book starts then in a very particular atmosphere of, or perhaps you can talk to us about what that was like, because it sets the tone for the action that was then documented in this book.
Thank you, Anna. Just before I answer that first question, I want to say how pleased I am to be in this wonderful building, in this wonderful city. I've actually been in Australia for over a month and so have very much become acclimatised. I also want to begin by slightly embarrassing Anna. When I was asked whether I'd be willing to speak at the Melbourne Writers' Festival, I said absolutely, I'd be delighted. I would be in Australia, I'd be teaching at the law school at Melbourne for a few days. But also, if I were to do it, the person I'd want to be in conversation with is Anna Funder, because I had not met her until 20 minutes ago, but I had read her book. And her book, for me, was very inspirational in showing how important it is to go beyond what you see on a television screen, what you read on a piece of paper, and actually to meet the people who are involved in the actions that you're interested in. And on the question that you raise, what was the mindset, it is very important to go back to the the months that I describe in the book. I tell the story of a single piece of paper authorizing the interrogation of one man, who we'll come back to in a few moments. Everyone I spoke to, without exception, as I traveled around America tracking down the paper trail of individuals, would use the same refrain. You have to understand, Mr. Sands, what the mood was like in September 2002. It was the anniversary of September the 11th. 3,500 people had been killed. We were getting intelligence that more attacks were imminent, and we felt we needed to do everything possible to stop future attacks on the United States. And everyone meant everything. I had one conversation with the combatant commander, the man who ran interrogations at Guantanamo, and he described himself to me as the man who was the point at the tip of the spear protecting the United States from further attacks. So that was one aspect of it. Another aspect, and I think we'll come back to it, was what was going on in popular culture and in the media. There was a move towards allowing abuse on the assumption that it would provide useful protection.
I think that there's one other little thought experiment, which is the ticking bomb scenario, that perhaps you could just describe to us, because I think that encapsulates the feeling of what was going on.
Well, the ticking time bomb scenario raises the situation which I think, in a sense, we all ask ourselves. Probably most people, if not everyone in this room, would say, are there any circumstances in which I would authorize torture? And the answer usually to that is no. In law, domestic law and international law, no means no, and there are no exceptions. And the rules of international law that I'm interested in, the Geneva Conventions famously, the Convention prohibiting torture, say no means no in all circumstances. Then everyone I'm in conversation with conjures up the so-called ticking time bomb scenario. You've got a situation in which you have a man or a woman who has information which would allow you to prevent a massive explosion that would kill or maim thousands or millions of people. In those circumstances, is it not justified to use torture? And that's a difficult question, and it admits of a number of different answers. One immediate answer, of course, is that situation has never actually arisen. No one is able to identify a single case of that having happened. But assuming hypothetically it were to happen, the next answer is, actually, the question assumes that torture or abusive interrogation produces reliable, meaningful information. And the one thing I learned in writing this book, maybe you had the same experience, when you talk to people who are interrogators, who spent years and years interrogating for the FBI, for the Army and Navy, for the police, they'll tell you that it doesn't produce reliable information. And that's the second element. And I've gone through the various stages of asking myself questions, and I've come out in the place which says no, never means never in law. It may be that someone may decide that they wish to go down that route, but if they do, they have to do it taking full individual responsibility for all of the consequences.
I was very interested to read, I think it was Doug Feith, the senior policy advisor to Donald Rumsfeld, in your book, and he says, this war on terror is not a conventional war. In a conventional war, we have satellites and they can identify the, he calls them formations, armed formations of the other side. And in this war, the only information we can get is what's inside people's heads. And I think that they were perhaps seriously imagining this in their minds as a ticking time bomb scenario, where they had to interview Mohammed al-Qahtani, who was the alleged 20th hijacker from the September 11 attacks, to see whether a year on, as if a year on, he would have information that would stop another attack. Is that the thinking at the time?
Well, it's probably worth saying something about Doug Feith. Some of you will recognise the name of Doug Feith because he's been much in the news as the man who is said to have been most instrumental, along with Mr. Rumsfeld and Mr. Cheney, in pushing the war on Iraq. He was the number 3 in the Pentagon. He was the Undersecretary of Defense for Policy. I spent a couple of hours with him. He's extremely unhappy about what I've written in the book. I've testified with him. Since the book came out, it has caused hearings in the US Congress. he comes from a background which I think, to put it at its most generous, a certain skepticism about international rules constraining what the United States does. He has a semi-detached relationship to facts. That was extremely clear to me. He's now mounted a vigorous attack on me, which I'm enjoying enormously. He's accused me of everything under the sun, misquoting him, being dishonest, lying, and so on and so forth. He has other troubles, though, which have overtaken him even as he attacks me, which is that he's just, in this past week, been fingered as the man who is thought to have organized the forging of the Iraq effort to buy uranium in Niger. Some of you will remember that. So he's an interesting character. And when you're sitting with Doug Feith and he says to you, we needed to get what was in these people's heads out of it, you says, oh yes, well, let's talk a little bit more about that. You need to understand the mindset of someone like Doug Feith. The instant decision after September the 11th was to take a decision to declare a war against terror. And I think that was a very big mistake. It's a big mistake to which Britain and Australia, I think, contributed significantly. But it was a big mistake because it took the response to the terrible events of September the 11th, and I remember them well. I happened to be in New York on that day teaching at New York University Law School, but it situates the response to those events into a paradigm of war, and rather than enforcement of criminal law. And once you situate the response in that paradigm, you run foursquare into the rules of international law governing warfare, methods and means of warfare, which of course no country has done more to put in place than the United States of America. One of the reasons I think it's been difficult for people to attack me on the book is it's abundantly clear that I'm hugely respectful, hugely fond of the United States. There's no other country that is going to go out in the world and do what was done after the Second World War and maintain those sorts of rules. And this book essentially is about the inconsistency of the US position. Having declared a war on terror, they then got rid of all of the rules.
Could you speak up, please?
Having declared a war on terror, they then had to get rid of all the rules they themselves had put in place, which placed constraints on how warfare was conducted. And Doug Feith played a very central part in that.
I think the nomenclature calling it a war on terror goes both ways. As you say, it traps the governments into at least nominally taking account of the laws of war. But Julian Burnside, a prominent Australian human rights QC, has made an interesting point about that, which is that if you say you declare this as a war on terror, it has its uses for a government as well, because it puts the executive on a war footing, and they can then say there is terrorists out there and we are going to protect people from them, and that protection is going to cost a little in the individual rights and freedoms of people. We are going to want to be tapping phones, and we are going to be wanting to put people in detention without trial and so on, as we've seen happen. So that has had its uses, I guess, as well.
I've no doubt that decision to declare a war on terror was motivated by strategic considerations of basically rallying the people, rallying the population in order to allow the executive to go further than it would otherwise have gone. But it was a decision that was taken incompetently and without any consideration of the consequences. For example, if they had gone to the British and said to the British, what are the implications of us going down the route of declaring a war on terror? The response would have been, don't do it. Don't do it, because that was the lesson we learned in relation to the IRA in the 1970s and in the 1980s. The IRA was desperate for their detainees to be treated as prisoners of war, to be subject to the international rules under the Geneva Conventions, because it was understood that by declaring a conflict as one of war-armed conflict, you legitimate the struggle. You turn criminals into warriors, you extend the conflict, you make it more difficult to stop the recruitment drive. And that's, of course, exactly what happened. But no one in the administration turned their minds to that question. And the consequence of that, of course, is they have, I think, extended the conflict by situating it in the paradigm of a response of war.
Julian called it, a war on terror is a war on an abstract noun. It has no identifiable foe and no identifiable territory and no identifiable end. So that increases its usefulness, I guess, to executive government.
Well, you also get absurdities. Some of you will be aware that over the past few days, the first of the frankly appalling military commissions at Guantanamo has delivered its judgment. It has delivered its judgment in relation to a man called Hamdan, who's alleged to be the driver of Osama bin Laden. And contrary to the Bush's administration's efforts to get him convicted for 30 years, they only got him convicted for 5.5 years. Well, he's already been in Guantanamo for 5 years, so he will be out on normal principles in 6 months, except that he won't be, because the administration has said, once the 5.5 years has passed, he will remain in custody, and he will remain in custody until the end of the war on terror. And taking Julian's point, that there is going to be no end to this war. It is going to go on for years and years and years, and they will hold this man literally forever on their own logic.
In that sense, it does remind me a little bit of some of the work in Stasiland, where the GDR was a country that was also on the front line of the war against the West, and it said the Western imperialists and terrorists are going to come and get us, and we are going to protect you, our people, from that. And the price of that was something that I was examining in the same way that you're examining that. I think we should get a little bit specific about the book now. Could you tell us about who detainee 063 is, what happened to him, and how he got to Guantanamo Bay, what happened to him there, and then we can perhaps talk about the memo.
Sure. Detainee 063, and they arrived sequentially, so he was an early arrival at Guantanamo, although a little later than David Hicks, is a Saudi Arabian national by the name of Mohammed Al-Qahtani in his early 20s. He arrived in Guantanamo in late January or early February 2002. And in June 2002, the people down at Guantanamo and in the Pentagon's Defense Intelligence Agency worked out that this was the same man who had 9 months earlier sought to gain entry into the United States. In August 2001, a few weeks before the September the 11th attacks, Mohammed Al-Qahtani flew in to Orlando Airport in Miami, Florida. At the same moment, the administration alleges that Mohammed Atta, the leader apparently of the September the 11th hijacking group, was waiting in the arrivals lounge for some person at the same airport. And for that reason, they put two and two together later on and worked out that, alleged that Mohammed Al-Qahtani was the 20th hijacker who was due to meet Mohammed Atta. But he didn't gain access to the United States. The customs people, the immigration people, were not convinced that he had sufficient money. He only had a one-way ticket. And so he was removed, sent back to the Middle East, and a few months later, in November 2001, he was caught in Afghanistan, and then later on ended in Guantanamo. So the key point is, June 2002, they've got this guy, they think he's the 20th hijacker, he's been interrogated with normal rapport-building interrogation techniques, they haven't produced any results, and the book tells the story of what happens next.
And what was it that sparked your interest in this, and what put you onto the Haynes memo? Can you tell us how that then went? How you tracked effectively the fact that the torture that was happening at Guantanamo Bay and at Abu Ghraib was orchestrated by the politicians and lawyers around President Bush very directly and not coming from the ground?
Well, the memo to which Anna's referring, which, I mean, this is the book is the story of a single piece of paper, basically, a single A4 piece of paper. It's a very famous piece of paper in the United States. It authorized the use of 15 techniques of interrogation out of 18 listed, blanket use, at Guantanamo. It's dated the 2nd of December 2002. It's famous because of what Donald Rumsfeld, who signed it, it was recommended to him by his lawyer, Jim Haynes, and at the bottom he scribbles famously, "Why is standing limited for 4 hours when I stand for 8 to 10 hours a day?" The document had attached to it a list of interrogation techniques, and it became public only 2 years after it was written and signed, in June 2004, at a very critical moment that many of you in the room will remember. In June 2004, the administration was desperately trying to respond to the growing scandal about Abu Ghraib. And in that response strategy, it put out a series of documents to say, we don't do abuse. The pictures you've seen at Abu Ghraib have nothing to do with administration policy. Here are the documents to prove it. And this was one of those documents, to show that they followed the rule of law, to show that they proceeded with care and deliberation. But the document had little clues in it. When I first saw it in June 2004, I dealt with it in the first book that I'd written, Lawless World, but didn't make it a centerpiece. And I only came back to it a year and a half or so later, when the interrogation log for Mohammed al-Qahtani came out. And once I'd been suggested to meet some of the people involved in the paper trail. So the first catalyst for writing this book was the emergence of that piece of paper. But the second catalyst came about a year or so later, when I was struck by the flu. I was lying in bed, I was channel surfing, and I came across the opening shots of a wonderful film that I'd seen 20 years earlier, Judgment at Nuremberg. Spencer Tracy, Marlene Dietrich, Montgomery Clift, won an Oscar in 1961. And it's a film that all of you really should watch. It's an extraordinary film that tells the story of a group of 3 German lawyers who are being prosecuted by the United States military in Nuremberg in 1947 for having crossed a line into criminality. And as I watched the whole film rather spellbound. If you're particularly interested in the closing scenes, just go onto YouTube, type in Spencer Tracy Nuremberg, and you'll get the fantastic 5-minute verdict that Spencer Tracy gives, which is one of the most moving pieces of cinema I think I've ever seen. I did a bit of research on the film, and I discovered that it was a film based on a true story concerning the responsibility of lawyers for abuse, obviously on a totally different scale from Guantanamo. I'm not for a moment comparing the two, but I was interested in the question, how did the lawyers do it? And so what I decided to do, armed with this piece of paper, armed with the instinct of this marvelous film, Judgment at Nuremberg, to basically track down every person in the decision-making process, and in particular focus on the lawyers, who it turned out were trained at Harvard Law School and Georgetown Law School, these wonderful lawyers, wonderful law schools, all of whom had been willing to sign off on abuse. And I couldn't understand how it was that these lawyers had done it. And it's that story that I embarked on.
Could you tell us what happened to Mohammed al-Qahtani at Guantanamo Bay, very briefly? And then I'd like to get back to the responsibility of the lawyers for war crimes.
There was a huge fight at Guantanamo in the months of September, October, and November 2002. One group of people that I met from down there were strongly opposed to any form of abusive interrogation. They took the view that the United States military does not do abuse or cruelty in any circumstances. And this is an honorable tradition that goes back to 1863, a decision by President Lincoln: military necessity does not admit of cruelty in any circumstances. That group lost out to another group which comprised the combatant commander at Guantanamo, Major General Mike Dunleavy, and his lawyer, Diane Beaver, and then a raft of characters going all the way up the chain of command to the chairman of the Joint Chiefs, who I met, to Mr. Rumsfeld's lawyer, Jim Haynes. The narrative that the administration had publicly spun in June 2004 was that the whole episode was an example of bottom-up decision-making. In other words, the initiative started at Guantanamo, and by the time it reached Mr. Rumsfeld's office, he was simply signing off on what the people on the ground, the military, who knew best, were recommending. And this looked counterintuitive to me. It looked not right and accurate. And I wanted to get to the bottom of what had really happened. And of course, what I discovered in the context of talking to many people who'd been involved in the decision-making process was that the opposite was true. It had come from the very top. And in particular, to give an example, I uncovered through Mike Dunleavy and Diane Beaver, the people down at Guantanamo, there'd been a hugely important visit in late September 2002. No one had written about it. It had not emerged into the public domain. But on the 25th of September 2002, President Bush's lawyer, Vice President Cheney's lawyer and Donald Rumsfeld's lawyer made a trip down to Guantanamo together on the same executive jet. They met with Beaver, they met with Dunleavy, they watched some interrogations, and they left Beaver and Dunleavy with the message, do everything that needs to be done. And coming back to Anna's first question, imagine the scenario for the people on the ground in Guantanamo. I'd been extremely rude about Diane Beaver's legal advice, authorizing these techniques of interrogation in my first book, Lawless World. I think it was ghastly advice. I still think it's ghastly advice, but I now understand the circumstances in which she wrote it. Imagine you are a low-grade, inexperienced female lawyer at Guantanamo. These three most powerful men turn up at Guantanamo and leave you with that message. The pressures are extraordinary. And whilst I don't justify what she did, I understand the circumstances in which she signed off, but I also understand that it came from the very top. It didn't come from Beaver and Dunleavy.
In a very real sense, though, if Donald Rumsfeld says, I'm just signing off on the advice of a lowly person at Guantanamo Bay who is not an international lawyer and she's been put in a position to give international law advice, and I am approving it, what difference does it make?
I talked about that with some of the more senior lawyers. A number of people described to me the Department of Defense, the Pentagon, as the largest corporation in the world. So it's a bit like, one of your Australian corporations, BHP Billiton or ANZ Bank or whatever, facing the most important decision the institution has ever faced, because that's what it means for the military to move to abusive techniques of interrogation, and asking the most junior lawyer in the organization to sign off on that decision. It is absurd, and it was counterintuitive to me. I know that's not how the American military works, and what I uncovered, and I tell the story, it was a long process of investigation, is of course that didn't happen. They didn't rely on Diane Beaver's legal advice. She was scapegoated. They outed her legal advice in ways that have caused her terrible grief, and denied that any legal advice had come from any other arm of government. But of course I discovered that was not the case. The key legal advice had come from the Department of Justice. It predated Diane Beaver's efforts. It was the sign-off of two legal memos in August 2002, which redefined torture and which authorized these very same techniques of interrogation, more or less the same list of techniques. The redefinition of torture was dramatic. Even more famous than the Rumsfeld memo is the memo of the 1st of August 2002, written by a man called J. Bybee, who was a Deputy Assistant Attorney General, but in fact authored by an academic from Berkeley, who's now back teaching at Berkeley Law School, amazingly, John Yu, and it's known as the Torture Memo. And this is the memo which abandons the international definition of torture, abandons the US definition of torture, and substitutes it with a new definition of torture. Pain which is equivalent to death or organ failure, nothing less. That is what torture is, and anything below that is permitted in the sense that it is not torture. And those were the documents that were in fact actually relied upon. So the entire narrative spun by the administration was a lie, and it was a lie which scapegoated the people on the ground at Guantanamo.
Your book has now given rise to these series of House Judiciary Committee hearings in the US. If we could talk perhaps about the case that you make, which is very strong, that the lawyers for Dick Cheney and Donald Rumsfeld in the Office of Legal Counsel, and I think by implication, although you don't spell it out, also those politicians, are responsible for war crimes. And you say of the lawyer, you go to talk to a European prosecutor and a European judge at international law who basically say, I think that those people should be very careful where they go if they travel outside the US. So can you tell us how international law could make those people responsible for the war crime of torture?
Just by way of context, there's no question in my mind, or indeed of the mind of the most senior US military lawyers, since they've testified to that effect before Congress now, that the treatment of Mohammed al-Qahtani was a war crime. He was, well, some would say tortured, others will say abused in a way that constitutes a war crime. And in fact, that has been in effect confirmed by the US Supreme Court. The techniques that I have written about